Hi guys, it's Kathy. I hope you're doing well. Welcome back. I know it's only been a couple hours. It's fine. It's fine. Bobby, if you're here, you might want to skip this first case. It's about, I don't know how many minutes long. So we have 3 custody cases this morning we're going to start with. They're not that long. But the second one is one we need to hear. It's very short. The first one is just going to tick you off. And then the third one is just going to tick you off. Bobby, you're really not going to like the first one at all. Judge something or another, Stalbrink, Indiana. Right? Yes, in Indiana.
Caitlin Cooper.
Okay. This is 46D02-1012 DR393. So the parties each appear in person. Pro se, we're here on a petition to modify custody. And that was filed by you, sir, correct?
Yes.
All right. All right. Have you guys come to any type of agreements?
Every time I try to talk to him, it's pretty much just bashing me, and I got a lot of proof on that.
So that's no?
No, sir.
That was a simple question.
Oh, okay.
But there is no agreement?
We go by the guidelines. Well, we do every other weekend and one day out of the week, but we opted out. My daughter doesn't come with the one day out of the week because it's like 4-hour visits.
Yeah.
And she's a teenager now, so she got plans and whatnot. So I get her every other weekend and summer vacations and stuff.
And are you still asking for a change of custody, sir?
I would like to, because the reason why I filed in the first place, yes, but it's been a 4-month long thing, so it's CPS just said they dropped the case, so I feel like nothing was helping so I don't know what to do.
A lot of times that happens, that we see there's an emergency alleged, and then we get to court anywhere from 4 weeks to 4 months later, and the emergency doesn't seem to exist anymore. So, but doesn't mean that there can't still be a question about custody.
Right, and that's definitely why I came and showed up, because I don't. With CPS dropping the case, I thought I did everything right. Gave it all the evidence I had at the time, and it seemed like they just dropped the case like it was nothing. So I kind of gave up in some sort of way. But I had the court date, so I'm here, and I wanted to see what I can do, what can be done.
Let me hear from both of you then. Raise your right hands, each of you. Do each of you swear or affirm under the penalties of perjury that the testimony you're about to give will be the truth, ma'am?
Yes, sir.
Yes, sir.
All right, I'm going to ask you some questions first. Tell me your full legal name.
Lennon Earl Barth.
Mr. Barth, you have children with Ms. Cooper?
Yes.
1 or 2?
1.
Okay, and that's Krista?
Yes.
Date of birth is
4/7/10. Yes.
Okay. And so at this point, she is going on 16 years of age.
Yes.
And right now, you guys have a guideline visitation where you're doing parenting time every other weekend, and during the week, she lives with mom, correct?
Yes.
You filed a petition for modification of custody because there were some allegations of things in the home that took place while the child was present.
Yes, sir.
And there was a Department of Child Services case that was pending?
Yes, from what I did.
Or at least an investigation?
Yes, there was. Yes, we sat with them and everything, but when I did a follow-up, they said they were dropping it.
You have 2 things listed, like 1, always moving, and 2, some type of attempted murder in the home while the child was present.
Yes, sir.
What do you mean by always moving?
There's never been a stable home. There's always been different.
Judge, he listed 2 issues: always moving and an attempted murder in the home while the children were present. And you start with always moving? You pick that one as the priority? Come on.
different place, where she's always on the move.
Is it like every month or every
No,
year?
no.
Or
It's
like each time a lease expires?
it was bad in the beginning. It got a little bit better, but she's still not disabled.
It's when my lease expired. Oh, I'm sorry.
I'll get to you in a second.
Okay.
Okay. If you have a legal objection, you can make an objection, but you can't object just because you don't like what he's saying.
Okay, I just didn't know if I was able to because I only moved for the leases being
I'll come back to you in a second.
Okay.
And then as far as since your last court order, how many times has she moved? Looks like your last stipulation was 2023, so about 3 years ago, 2.5 years ago.
2 or 3 times, I think.
Okay. And how is Krista doing in school?
From my understanding, she's doing great. I think she's got 1 bad grade in class, but it's not even a bad grade. It's just lower than the other ones.
And
She does honor classes and stuff, so.
does she have a plan for when she graduates?
She's still thinking about it. She has many options, so she's on the table.
Okay. And you are able to have those conversations with her?
Oh, me and my daughter have a very open relationship. Very open relationship.
And you're able to talk to her even if it's not your weekend?
Yeah. Well, we text and whatnot. We got each other Snapchat. We snap each other every morning. We text every day.
Okay.
Well, almost every day.
And is she involved in any extracurricular activities like sports or school stuff?
We did soccer a couple years ago. She was in next when she was younger. Now she's a teenager right now. She started attending church a lot, doing church activities and stuff. So.
Okay. What happened in the home with this murder or attempted murder incident?
From my understanding, what I got of it was there was 3 felons living in the house at the time, which I had the names of, but I know, I wish I would have, but like I said, I gave up after CPS dropped it, but I'm going to do
Was there an actual killing or shooting in the home?
attempted murder? Yes. A guy was shot in his head in the living room.
Okay.
Yes.
And was she involved in that?
My daughter was present in the household in the other room.
Okay.
And from my understanding, her little brother was in the room when it happened.
It's sort of standard. He gets like weekends and maybe 2 weeks of summer or something like that. I don't know. Mom has the 16-year-old most of the time.
But Department of Child Services investigated and did not do anything.
No.
Okay.
Like I would have thought I could have got emergency custody then at least until they could have sorted out, found out whatever was going on. Nothing. They didn't help me in no sort of way, shape, or form. I did a follow-up and they said they were basically dropping the case.
Is your daughter in any kind of counseling or anything?
And from my understanding, I'm surprised she's not, because a couple of days after the attempted murder, she took the kids back to the home to do cleanups, and I told her, like, you don't need to be there. She's like, no, it's okay. There's bed sheets over the blood. So I called the cops and did a wellness check. Cop checked it out. Cop called me back, and he said, no father to father. No child should have been in that home. He said the blood was clear as day. And they were there for hours at end because I got my daughter's location and I can see where she's at. And they were there hours at end after the attempted murder with blood being everywhere. And that, to me, that's not showing no care of anything to your child.
But she's doing okay.
Which is, for my, yeah, she's strong. She had to grow up very young. And she'll tell you she's okay till she's blue in the face. But I know my daughter.
All right, let's go to Mom. Mom, tell me your full legal name.
Caitlin Marie Cooper.
Mom, you heard Dad's testimony, correct?
Yes, I did.
What is your response to the constant moving and not being stable?
I only moved, sir, because they ripped out a gun in 7th grade in Michigan City schools. So I have drove my daughter for the past couple of years to LaPorte. I even moved my life to LaPorte to get her away from that. Her dad refused to help me get her to LaPorte schools after the gun was ripped out at Barker Middle School. So that was the reason for me moving again. And then I only moved to get them away. They gave me.
Since 2023, she would have been in high school at 20.
Does anybody have any idea what she's saying and what it means? To me, it sounds like she's saying They ripped out a gun. So she moved because they ripped out a gun at the school. I have no idea what that means. The child is 16 years old right now.
Yes, I've been driving her to LaPorte, even from
How
Michigan.
many times have you moved since 2023?
2023, I moved from my 2-year lease. I moved to Maple Tree and I had a 1-year lease, but since the gun happened, I got the kids out of there as soon as possible. I had 10 days to get all of our stuff out and I left most of it.
Since
And
the gun happened, what are you talking about?
a guy came in my home. He's saying they live there. The guy did not live there. He shot somebody that I was, he just walked in my home and he ripped a gun out. I am traumatized. I've been lost 30 pounds from it. And the guy that got shot was somebody I've known since I was 8 years old. And it was blood squirting out of him. And I had to hold that on my hand on there and I saved his life.
So your kids were around for that too?
No, they were sleeping, but they were in the home. And I never pictured anything like that happening. I've never been around anything like that. And I literally got us a new place to go.
So you moved because of that?
Yes, I moved
That was in
because
2025. How about in 2023 and 4?
I lived at, I'm trying to think. We moved in and from 2022 to 2023, we had a 2-year lease in Michigan City at Oak Street. So we moved after the lease was up to LaPorte, so it wouldn't be as hard as on me to drive my daughter to school because I've kept her in LaPorte schools for her safety, and she does a lot better in school. She has anxiety.
So you've moved how many times?
In the past
Since 2023.
2023, I would say we had to move one extra time, so 3.
Okay. So pretty much what Dad said, 2 or 3 is what he said.
Yeah, but one was because the lease was up, and then the other reason was I wanted to get to LaPorte because it was hard on me going back and forth to Michigan City to LaPorte.
And then one was because somebody got shot in your apartment.
No, I broke the lease in 2000, or I didn't break the lease. The lease was up as of 2024. So we stayed in 23, 24, 25. So yeah, we stayed in a house in Michigan City from 23 to 24, a 2-year lease, and that was up. So we moved to LaPorte, and my lease was about to be up either way, but I got the kids out of there and into a new place because of the gun shooting, yes. And a child support, told me I'm doing everything right.
Why would you take the children back to clean up the blood?
No, I didn't do that at all.
Well, you took them back in the apartment with all.
The cops suggested that we would go back there and get all our belongings, and then we left. Like our
Had you
toothbrush.
place to leave the kids while you did that?
No, their dads do not communicate with me. They don't do doctors or dentists. They won't pick them up.
So did you try?
Yes, I did.
You called Dad and said, hey, you watch the kids, I've got to deal with something?
Yes, I did. And then his 2
He
weekends.
said no?
Yes. And then his 2 weekends prior to that, sir, he thought she was in danger, but he didn't even get her for his 2 weekends after that gun shooting. And I even asked him, if she's in so much danger, why would you not pick her up?
Is she in counseling?
We are actually just had a counselor, but they cannot do after school meetings, or they can only do it during school hours. So I'm looking for a different one. I don't know if you guys could recommend a few.
I don't do that.
Okay. Well, I talked
This
to,
happened in October or September? When did
I'm so traumatized. I can't even remember. I know it's in one of the two.
So you're traumatized. You don't think that had effect on your children?
They didn't watch it. I had to hold the blood in and call 911, and I thought he was going to die.
After the gunshot, they never came out of their rooms?
No, they didn't come out until the police directed them out. My son, the police directed me to actually wake my son up and run down the stairs to direct the police, but my son did not see anything or nothing like that, now that I think about that. But my daughter was asleep the whole time, and she did not wake up.
So if I talked to her, that's what she would tell me?
Yes. And I would like to call her in as a witness
She's so full of shit.
to some other things that have happened
Do you have anything that you filed?
with
The court?
regarding my daughter.
Well, you said you wanted to call about other things that have happened right now. We're here on a custody regarding being unstable and moving and an attempted murder. Did you?
Yeah, no, I was just saying she's been in my care for 15 years. She's almost 16. And I'm just saying I've done all the doctors, dentist, I wanted to hand this letter as well.
Who's it from?
I wrote this out.
No, you can just tell me what you want to tell me. Because you're
Okay.
under oath as you're talking.
Right.
Is she involved in anything else at school?
She actually has health problems since the age of 5. Her father refuses to believe it, so she has dropped out of all
I'm
extracurricular.
not talking about sports. She could be involved in chess club or
Oh, she goes to church. She goes to church and she goes to a youth group.
what church does she go to?
I can't remember the exact name of it. It's
So
she
it's
can
not-
tell you.
It's not something she attends with you.
No, she attends it with her boyfriend
Is it here in LaPorte?
in LaPorte. Yes, her job's also in LaPorte.
Where does she work?
Blue Heron in the hotel.
The Blue Heron Inn?
Yes, sir.
Right there on Pine Lake Ave?
Yes, sir.
Good. And what does she do?
Just like house maintenance, like a maid.
How does she get back and forth to work?
With me, her father refuses to help.
All right, Dad, anything you want to tell the court based on hearing from Mom?
Yeah, actually. But the whole me not wanting to help thing, that's beyond me. Last summer, I actually had to have my son's mother because I get my kids for a full week every other week through the summer vacation. And I work a full-time job and I own a little small lawn care business on the side too. And so, and from my understanding, she hasn't had a job in years and didn't have a job through the summer vacation either. So in my mind, even if it's my weekend and my daughter has to go to work, my first contact, I asked her, would you be able to take her to work, since I have to work, because my daughter had to be at work on Saturdays.
Are you aware of her working though?
Yeah. But she had to work when I had to work. And so I simply asked her mom, can you help out, get her to work? Because I have to be at work 2 hours before she had to be at work. And so she refused and she said, well, since she's in your care, you got to figure it out. And so I did. I got a hold of my son's mother, my other person, and
But she is correct. If she's in your care at that time, it's up to you to figure out transportation.
and that's okay. That's fine.
Sometimes parents work that out amongst themselves, but if you can't work it out, it's still up to you.
It was just
In her week, it's up to her. If you guys, because if she asked you and you said, yeah, I'll give her a ride, that's great. But if you're not available, then it's up to her to figure it out.
I was basically saying I've never refused. I've always had to work when things have had to go on. I cannot just up and leave my job when she doesn't work.
I do work, sir.
Well, here's what I'm going to tell you. It sounds like you're raising an amazing young lady, even though you two don't get along. And I hear Mom taking a smack at Dad every chance she gets. And Dad disagrees with Mom. I understand you're both going to disagree. Hopefully you're not saying these types of things in front of your daughter. Because what I will tell you, even when you're talking to your friends or talking on the phone, the kids are listening, because I'll have parents tell me, oh, I never say bad things about my ex. And then when I talk to the kids, I find out they can overhear you and they hear you saying everything. And guess whose feelings it hurts? It's not him.
Exactly.
It's her.
Oh, yeah.
Because she's apparently got a good relationship with Dad, which I think is awesome because we don't always see that.
She was actually just telling me she hasn't even talked to her dad or texted him. I didn't even know that.
So,
That they've barely been in communication. So I don't know how much of his words are true.
well, what I'm going to tell you is even if they're true or not true, there's not enough to change custody based on what I'm hearing, because you have a daughter that's very stable and doing well.
Yeah, she's very stable.
Ma'am.
I'm sorry, Judge.
I don't know how much I can say. It's hard to change people and it's hard to get people to change, but you've talked over me. You've talked over Dad. You don't answer questions when I ask them. You talk around them. And that none of that's productive or helpful.
I'm sorry. That's why I wanted to present this. I'm very fearful in events like this. My anxiety is. That's why I was trying to present this. I apologize.
I'm going to deny Dad's request for change of custody at this time, just because there's not enough evidence for me to do that. I hope Dad maintains that relationship with his daughter that he testified about and maintains that contact. because at 16, you're lucky to get any attention from a teenager because they got their own life and they think they're already 25 years old and they're not. But in 2 years, she's going to make up her own mind. April 7th, she's going to be 16. And then 2 years from there, she's going to do her own thing and she doesn't have to listen to you guys. So from that standpoint, I hope, Dad, you maintain that contact. Your request to change custody is denied. Mom will retain residential custody. All parenting time will remain the same. I'm glad you guys do 1 week off and 1 week on in the summer. I think that works out better for everybody to be able to do that. So when I see these over and over, those schedules seem to work the best for summer parenting time. And the child can rely on that. So.
Yes.
All right. So that's my order. We'll issue something out to each of you. Have a good day.
Thank you, you too, Judge. Is there any way I can present this to somebody? It's, he's been on Facebook making memes of me and,
You can file a motion with the court.
okay.
But
Yes. It was very hard for me not to go look up the memes, but I didn't because we don't do that here. We don't touch these people's lives in any way. But man, I wanted to see what memes he put up of her.
something I just accept. I respond to
Okay.
motions so that he gets a chance to see a copy of everything and then we come to court.
All right. I appreciate it. Thank you so much.
Good day.
You too.
That poor guy. That's not fair. That wasn't fair.
Okay. We are here in cause number 4060022207 JP101. Your name for the record
Evan Patke.
and your name?
Miranda Mormon.
So the parties each appear in person. Pro se, we're here today for a review. File shows me we were last in court. It looks like back in, is it November?
Yes.
Yeah, sounds about right.
Okay. And that was for review. How are things going now? Let's start with Dad.
Everything's going great. I have no bad things, no complaints or anything. Ever since the last court meeting, everything's been good. I've been getting them, according to your order, and if not more, like she's giving me extra time with them. I'm appreciative of that. So.
All right, Mom, let me hear from you.
I'm shockingly very happy with how things are going.
Good.
I think that it couldn't be going better. We're getting along just fine, and Noah's really enjoying going over there.
Sometimes it just takes a little time, put all that stuff aside,
Yeah.
and focus on your kid and how he's doing.
Yeah.
And he's doing good.
Yeah.
So he looks forward to going to see Dad.
Yeah. And, sometimes he'll ask and I'll offer him to take Noah. And
And he looks forward to going back to Mom. He's not fighting on any of that.
No.
Yeah, that's a very pleasant surprise
Yeah.
for me. So we don't hear that as often as I would like. So I'm really proud of both of you for stepping up and putting some of that noise in your head aside and just focusing on him. So even though the Bears let us down, you got the Bear sweatshirt on. But
Always next year.
Yeah, so, yeah.
I'm sure it looks bright.
yeah. So I'm going to show that you guys have appeared. I'm not going to set this for any further reviews. You guys are A students right now, doing well with everything. So you don't need
Psychopaths. They must be psychopaths.
me unless something happens where you think something needs to be filed. And if you file something, then I'll review it and possibly set it for hearing. Okay.
Okay.
Thank you both for making my day.
Thanks.
All right, thank you.
Sir.
So, again, I was saying this the other day. We only see the cases that go wrong. So, if you watch my channel, you would say that that splitting custody never works, ever. Parents only ever fight over kids in a divorce. That's not true. It's just not. Lots of parents do fine. They just do. We just don't see them.
you.
Oh, this is going to be...
All right. This is 4060021810 JP227. Your name for the record?
Alicia, matrician.
Thank you.
Luke Harden.
Thank you. So the parties each appear in person, pro se. We're here today on a motion for status update filed by father. Did you receive a copy of that, ma'am?
Yes.
And I guess I was trying to figure out what, in fact, Dad was asking for. So we set this for a status/review today so that we could kind of see where things are at and what, if anything, we needed to set this for hearing down the road. So Dad, why don't you tell me what's going on?
Me and Mom had initially set it for a hearing to try and modify what we had in place on the previous orders to try and change something like Friday to Sunday. And so that's why it had actually been filed.
Okay, so what are you doing now as far as his schedule?
So I was previously doing Thursday, Sunday. I wasn't, that was temporarily changed. And I was to go to the visitor's house right here. And so I've been going to the visitor's house for some time recently. And we filed, I had in hopes to change it to, try and change it to this Friday at 6 p.m. to Sunday at 6 p.m.
All right, let me go to Mom.
He has not been doing his visits. He's only done 2 of his supervised visits. He does not have a place for Hunter. He does not have anything to provide for Hunter. I am not agreeing on anything that he wants. He is not stable for Hunter's safety. I'm not agreeing. Hunter is scared to be with him alone. He has only done 2 of his supervised visits. He has not done all of them. That is not enough.
And when was the last order out of this court?
It was a couple years ago. It was back in 22, I believe.
And Dad, where do you live at this point?
So I rent a place here in town. It's a townhouse, and me and another guy rent the place. I've been there for about 4 months now.
So when you were talking about it used to be Thursday through Sunday, that was way in the past. That wasn't like last month.
Oh no, that was a couple of years ago. Yes.
And the Department of Child Services was investigating back when this order was entered in 2022. Did they have any case open or do anything with that case?
So what they did do was they did come to my house, and they did come in. They took a look at Hunter's room, and they seen where his place to sleep was. They seen the kitchen. They also seen the pantries, and anything else that they desired. They also took a look at the bathroom, and they talked to me a little bit, and then they were on their way.
And so no case was open where you had to appear in court or anything like that?
No.
Okay. What about, I think the last order, let me go to Mom. The child was the child placed in counseling?
Yes.
Is the child still in counseling?
Yes.
And you are objecting to any change in the August 22nd, 2022 order?
Correct.
And how many visits have taken place at the Harmony House?
2.
And when was that?
1 in November and 1 in January.
Of this year?
Yep.
So there was a 3-year gap.
Yeah. Correct.
Because this order was August of 2022 and then
Correct.
not until 2025 did a visit take place?
Correct.
And has the child been in counseling ever since then?
Correct.
Some of the visits haven't happened recently just due to the weather.
There was a gap of 3 years, right?
Correct.
Why did
Yeah, but Judge, there's weather every day. There just is weather every single day.
they take place during that time?
I was just not financially in a position to be able to do anything for him. Around the time that the last incident that happened on the court document up until about a year ago, I'd been pretty much financially unstable, so I didn't see it in the best interest that.
Have you been working?
Yeah, I've been working for the last year and a half.
Okay. All right. Well, your motion.
You know, it's very expensive to have to see your child. It's very, very expensive to just, see your child.
Was not enough for me to set an order on custody change or any type of parenting time change. You'd have to lay out in your motion, 1, this is what my schedule is. 2, this is why I think I need more parenting time than supervised, and kind of lay everything out so the other side has a chance to see what the allegations are.
Okay.
Our local rules require that as well. Just so that I'm not surprised either when we come in and all of a sudden we've got issues that nobody's ready for or able to proceed on. So what I'll direct you to do, Dad, is if you think it's time to modify parenting time, I think you need to file that in a motion that lays it out as to why you think it needs to be modified and go back to regular weekends. But I can tell you that Mom's probably going to call a counselor as a witness. We're probably going to have evidence presented so that I can better understand what's going on with your son and with you. How old is your son?
He's 8.
Okay. So he's basically gone 3 years and only had 2 supervised visits with Dad. And did those go okay?
Yes, but only because there was somebody
There.
in the same place, yes.
So, Dad, I'll tell you, even with that kind of gap, I usually am looking to hear if there's a counselor involved from the counselor, and I'm looking to slowly kind of step you guys back into any kind of relationship that you can have. So I wouldn't just automatically order your weekend start tomorrow. I would want to see.
The balls on this man. Seriously. 2 visits in the last 3 years, and he's like, I think we should change custody.
A schedule of stepping down, and I'd want to hear what's in the child's best interest from the counselor. So I'll put it on you to file a motion that lays out why you think parenting time should increase. And then once I get that, we can set that for hearing, and then you can bring your witnesses in, Mom can bring her witnesses in, and we can go from there. Okay? Does that make sense?
Correct, yes.
So Dad, that gives you a path that it's putting it on your plate then to pursue this.
Okay.
Okay? Any other questions for the court from Dad?
I do. The paperwork that you speak of, where would I be able to?
You can, my court reporter will give you an online website to go to, and it lays out for parenting time and or / custody, and it's forms that you fill out. And you kind of filled out some of them, but they were set for review, not for actual modification of parenting time.
Okay.
And I'm not hearing anything that would give me a modification of custody, but I do step down parenting time all the time like this, depending on the situation. So I'd be looking to see some kind of petition to modify parenting time, and Mom can respond to that. And then I can hear from your witnesses and from hers, and we can go from there.
Okay.
Okay. Any questions from Mom?
No.
All right. So the previous order remains, and then we will see what we hear from Dad with his filings. And if, like I say, if we get a filing, we'll set it for hearing and go from there. Okay.
Sounds good.
All right. Thank you.
He could just, go see his child on his scheduled parenting time. He could just do that. All right, here we go. We're going to Jersey.
Yes.
No, perdón, yo nunca me he negado a tomar ninguna prueba de clínicas.
Pardon me, I never.
It's choppy because I edited out the interpretation, but not all of it. You'll see. I felt like a court reporter. Okay, their job is way harder to interpret, to write down everything that's said. All I was trying to do was cut out the interpretation, and they kept talking over each other. So I did the best I could. So a lot of it is gone. Let's just stay with that.
Never did refuse to take a breath test.
Okay, that was,
Okay.
some of the record indicates to me that there was a refusal, but I do not see the charge for refusal. I'll stand corrected in that regard. Please do not discuss the particulars of your matter because I don't want to hear anything from you in that regard until your attorney is present. But you should understand that as a third offense, if you plead guilty or found guilty after a trial, you face fines of up to $1,356, 8-year suspension of your license, 2 years with the interlock device, as well as 6 months in jail. Okay. As to the assessment as far as the bail is concerned, although I have touched on some of the issues, I'm going to ask you a couple of questions regarding them that have nothing to do with the offense itself, but are general questions regarding your circumstances in the community. Are you working?
¿Usted trabaja?
Yes.
And where are you working?
¿Dónde?
Wait for the translator, please.
Espere hasta que lo interprete todo, por favor. It's an excavating company that's in Hillsborough. It's called Abogantes Excavating.
Bogantes.
Bogantes, I'm sorry, interpreter correction. Bogantes Excavating.
Would you spell that, please?
¿Cómo se escribe Bogantes?
Bogantes.
Bogantes.
Yeah, I left our letters in so we can learn how to say our letters in Spanish.
No me sé el número de teléfono, señora.
I don't know their phone number, I'm sorry.
How long have you lived in South Bound Brook?
I don't live in
Okay.
South Bambrook, I live in Manville.
And what is your address in Manville? And the zip code?
The zip code?
08835.
08835.
And sir, do you live with your family or do you live alone?
I live with my mother and my fiance.
Con mi madre, I'm translating the wrong way, sorry. Deberá contestar en español.
Perdón,
I believe you.
I'm sorry.
That's
Vivo con
okay.
mi mamá y con mi novia.
With my mother and my girlfriend, fiance.
And do you have any children?
Que vive en
Not with her, but I do have a
Somerville.
16-year-old daughter. Que vive donde?
Somerville con la mamá de ella.
Who lives in Somerville with her mother.
But you tell me that your financial condition is such that you couldn't make bail at this juncture. Is that accurate?
Exacto.
Exactly.
Do you have anybody that could post bail for you?
I gave a telephone number. I gave him my telephone and when I got here, but I don't have the telephone at this moment.
Lo que me refiero es que no tengo el número de teléfono para contactar a nadie.
Like I said, the thing is that I don't have any phone numbers to contact anybody at this time.
Does your family know where you are?
¿Tu familia sabe dónde usted está?
No.
No. I didn't talk to any of them. ¿No habla con nadie de ellos?
No, yo hablé, desde que me agarraron y me metieron acá, yo no saben dónde estoy yo. Yo no he hablado con ellos.
Okay. No, since they arrested me, I've not talked to any of them.
You've also heard me discuss with you your prior failures to appear. Is there anything that you'd want to tell me in that regard that would make me I should know before I determine what to do as far as your bail and your release?
También, the last time I wanted to say that it wasn't that I didn't want the attorney, but she didn't want to work with me anymore. Okay, ¿qué más? And then another time I was moving and I lost the court date. I know I was supposed to find out about it, but okay.
Nunca recibí la carta. Yo me cambié.
I never got the letter. It's that not that I didn't want to come to court, but I didn't get the letter.
But sir, you also had $2,500 in bail that you forfeited because you didn't appear. And I have no memory of any record of your attempting to contact the court in that regard.
I didn't try to get in touch with you because, I just forgot.
Sir, I'm going to put it in plain language. If I handed somebody $2,500 on a promise that I would show up, I think I'd find it hard to forget.
I am so rich and famous that I often forget about $2,500 here and there. I'm sure I lost that much yesterday somewhere.
A lot of time went by between that time and when I got the letter, and I just totally forgot about it. And I know that I lost the money. Okay.
So at this juncture, what I have are several choices, sir. I can
Look-
raise the amount of bail that I'm asking for. I can
Look-
keep the amount of bail the same, or I can reduce the bail to nothing and release you.
Lo que puedo
I
hacer
have
son,
some inclination as to what I want to do, but I want to hear from you if there's anything further that you want to tell me.
Yo tiene que-
I'm asking you to give me another chance. I promise I'll
Por
come
favor.
next time.
Sir, I have set this matter down for another hearing in my court via Zoom, via the electronic platform on Wednesday, February 4th at 1 o'clock.
Señor,
1:30.
if he-
I'm sorry,
if he
1 o'clock.
hasn't-
And I've already arranged for the public defender who will be representing you to appear on your behalf at that time. Please understand also, sir, that it's my job as the judge to make sure that you get an absolutely fair hearing and that all considerations are provided to you.
Okay.
But what I
Okay.
have, sir, is a charge that's over 10 years old that was the subject of a number of proceedings in my court and other courts. And I find it difficult to believe that you completely forgot about it until the police happened to pick you up yesterday. And given the seriousness of the matter, the threat to public safety, and the amount of money that you forfeited as far as prior bail, I think I would be remiss if I were to let you go without remitting any bail at this juncture. So I'm going to maintain the bail at $2,500, no 10%. And I'm going to revisit this matter on Wednesday, February 4th at 1 o'clock via Zoom in the presence of your attorney. In the meantime, as part of my first appearance and bail review hearing order, I'm going to provide that efforts should be made to allow you to communicate with family members to see if bail can be raised.
Well, the only way I can communicate is if they give me my phone back so I can get in touch with them.
They have telephones at the Somerset County Jail.
Pero
and
tienen teléfonos en la cárcel.
There are efforts to allow detainees to use them.
Pero no me
Usemos
acuerdo de
teléfonos.
ningún número de teléfono. No tengo
But I
ningún
don't
teléfono de
remember the
nadie.
telephone number. I had it on my phone.
I'm sorry, sir, that is the best that I can do for you at this time.
Lo siento, señores, lo mejor que puedo hacer para usted en este momento.
I will see you on February 4th at 1 o'clock via Zoom.
Nos veremos el 4 de febrero a la 1 de la tarde.
In the meantime, I will make efforts to have your attorney contact you as well, and perhaps he can assist you as far as the bail issue is concerned.
Y mientras tanto, lo arreglaré para su abogado se comunique con usted también y quizás le pueda ayudar con lo de la fianza.
Thank you very much.
Gracias, muchas gracias.
Thank you, Josh.
He gave up at the end. That is Jersey. I get all these Jersey judges every day, and everything is so short. But it's all chaos. It's 100% chaos. Every single person that comes in the booth. You can leave the booth. I get in a coma every day that he streams. I'm actually getting a case in New Jersey right now. It's pretty bad. It's going on like I think it started January 13th. Maybe January 12th. And I didn't get every single second. I did not, but I got a lot of it. State versus Paul J. Sierra. I can't remember his last name. It starts with a C. He murdered he murdered 4 people. I can't remember who the fourth person is. Brother-in-law, sister, and their 2 children burnt their house down, came home, burnt his house down, and now he's in trial. It's a big deal. It's a big case in Jersey. Everybody's talking about it. It's been going on. It's a long trial. I don't even know. I think it's good because the Jersey lawyer She keeps getting in fights with the judge. But anyway, I'm still working on that. I don't know if I'm ever going to show it anywhere, but I'm getting it every day. I don't know if I did this one. I'm going to start this one. I don't think I did it, but if we've seen this before, let me know. I can't remember. They all smushed together.
Thought that this was a good idea that evening, early morning, actually. In the PSIR, the defendant stated that Shane Bowser, her co-defendant, just wanted to scare his parents because they were trying to get charges on him. I'm not really sure exactly what that means, but obviously is potentially victim or witness intimidation or tampering. I do have some video clips that are short to show the court because there were surveillance cameras all over Mr. Gregory Bowser's house. They don't have any noise.
That's fine.
And this is outside as the four of them are walking up to the door. You see somebody with a rifle, the defendant with a gun, and Eric Everett, with what we believed was a gun. And then inside the house, Mr. Bowser sitting on the right, and Miss Pittman is sitting on the other couch on the left. This video she had obviously heard something, and that's why she was looking that way, and then having this reaction to whatever she was hearing outside. The dogs start reacting because they hear something outside. And then she gets up to go into a back room, taking her purse with her. I believe at this point, Mr. Bowser's trying to think of whether or not he's going to let his son in because he was the one knocking and he was announcing himself saying, "Dad, are you going to let me in?" They had been having some ongoing issues with him. Ultimately, he gets up and decides that he's going to let his son in. He pushes his way past, and then everybody else comes filing in. The defendant was first. Mr. Bowser's trying to grab the gun from her. She points the gun at him. She also points the gun at Miss Pittman. Mr. Everett is pointing what appears to be a gun at Mr. Bowser as well.
How do you do that to your parents?
And ultimately, they leave within a minute.
How do you commit home invasion with a gun to your parents?
Of entering the house, having stolen absolutely nothing. Law enforcement pretty quickly identified and contacted everybody within a couple days. Law enforcement first contacted Mr. Bowser. He was with Mr. Everett. In plain view, they see a gun in Mr. Everett's truck. Mr. Everett tried to say that he had just picked up Mr. Bowser the night before, which would have been on the 4th. This occurred on the 3rd. Law enforcement contacted them on the 5th. So Mr. Everett was trying to tell law enforcement that he had just picked up Mr. Bowser the night before, stayed overnight to help around the property, and he hadn't seen him for 6 months prior to picking him up the day prior. They noticed that Mr. Everett had the physical character.
How do most of you hear it okay, but then some of you have no sound? If it was just one person that had no sound, I would get that. But it's not. It's multiple people, but it's not everybody. What the heck? What? I don't get it.
Characteristics of the male in the camouflage pants. There were multiple campers on that property. They ultimately contacted the defendant. She said that they also had picked up Mr. Bowser just last night. Her and Mr. Everett were reported to be in a relationship together. She admitted that they would find Shane's property in their camper along with methamphetamine and drug paraphernalia. Admitted that there was a 9mm gun in there as well, and the red bandana that she was seen wearing in the video. They searched the camper. They found a 9mm gun matching the gun that the defendant had in the video. There was one in the chamber, 5 in the magazine, and there was an extra magazine as well. And then they found what they believed to be was the gun that Mr. Everett had in the video in his truck. It ended up being a lighter that was designed to look like a handgun. And then Mr. Jensen was the one with the rifle. In speaking with Ms. Pittman and Mr. Bowser, they were actually the ones that had said that they believed that the defendant was the more aggressive out of the bunch, pointing a gun at both of them and yelling. And as the court can see, the 3 co-defendants, aside from Mr. Bowser, went in with masks on and guns drawn like they were going to murder somebody. And we're lucky that we don't have a death or a shooting here. But we can't let that diminish the fact that they went into this man's house with guns drawn and masks on for whatever reason it ended up being. Mr. Bowser had a large bag with him, which would imply that they were going to possibly steal things. At one point, he had told them to forget exactly what he said, but like the device that would have held the surveillance video. Nobody ended up getting that. Nobody walked out of there with anything at all. But obviously he was aware that there were surveillance. He wanted it to get rid of it, but they didn't. They just ended up leaving. I think the court needs to take into consideration when sentencing that they thought that she was the most aggressive. Also, it's not a correction to the PSIR, but the plea agreement, that she actually has 3 felony convictions. The plea agreement was incorrect. I was doing the best I could with the pretrial report that we got and her history as we had run it. But either way, she's been revoked on probation, ultimately sent to DOC on previous cases. She's scoring as a high risk to recidivate. I don't think that the minimum's appropriate. I don't necessarily think that the maximum allowed under the plea agreement is appropriate either, after reviewing the mitigation. So I'm asking for 13 years of DOC.
Thank you. Ms. Gurley, do you want to say anything?
Just that I'm sorry for my involvement in this case.
Yeah, looking through this, obviously, whenever I'm going through this case, I actually did the search warrant as well, initially in this case, whenever all that stuff was being found. And obviously, this was a very serious and aggravated case. Ms. Lawrence has indicated a couple of times in her argument that nothing was even taken. I mean, you've thrown away a large chunk of your life for nothing. And, and I see in your mitigation report, you're talking about Gotham, your daughter. And I know that you love her. I can see that just in the picture. She needs you. You need her. You got to find a way back. This is the kind of case where a substantial prison sentence is going to happen because this was very violent and it could have ended very badly. And you also have a history. But I'd like you to focus over the next pretty large number of years on getting yourself healed. I'm not a bit surprised about the things that I read in the mitigation report. A lot of times people that have these things happen to them end up doing kind of the same thing. It's something that keeps on going throughout the generations. You got to find a way to make sure that this evil that's been visited upon you is not visited upon your daughter. You know, I think this is tragic. It deserves a prison sentence and a substantial one. But at the same time, I want you to heal. But I can't heal for you. You've got to heal. So that when you do get out and you do have time with your daughter and your family, that you're able to be fully present. This is sad. I don't enjoy this. Obviously, you deserve a substantial prison sentence, and that's what you're going to get. But I really would like it that, you know, whenever you get out on parole and you get back with your daughter and your family, that you're able to have some peace with your soul from all the tough times that you've been through, the horrible times you've been through, which I recognize and acknowledge. You have the ability. It is never too late as long as you are still alive. It is never too late. And even while you're in prison, you can cultivate a relationship with your daughter and your family. Maybe they can help you with that. You need to understand that ultimately you're worth more than this. You are. You are worth more than what has happened here. You've made horrible mistakes in your life. And you've hurt other people. And that's why you're getting the punishment. But this is time for you to heal if you choose to take the right path. I know DOC is a very difficult place to do that. I don't pretend to have roses and rainbows coming out of that kind of situation. But you can, if you do the work and you make the right decisions. You, at heart, are a good human being. You are a good person who's done a horrible thing. You have every right to be with your daughter when you get out of here and live the best life you can. And so does she. She has every right to have a mother who is fully present and not hurting other people. And I wish you the best. I do. And I wish you healing. I wish your victims healing as well. So that we can all get through this and go on with our lives. But you need to make sure that you're looking in the mirror every day and saying, I am worth more than this. I am, and so is my daughter. So is my family. So to the extent that a judge can beg you to be on the right path, that's what I'm going to do. But consequences must flow from the actions that you did take. The court will sentence the defendant to 12 years in the Department of Corrections. I don't think the maximum is necessary, nor do I think that I need to go any higher than that at this point in time. That's a lot of time. The minimum is not appropriate either because what happened here and also your history. Those things have to be taken into account. But again, it is up to you. It is your work and it is your life. Please do the right thing. 148 days credit for time served thus far. No restitution, right, Ms. Lawrence?
I don't believe so. No.
No restitution will be imposed. Standard court costs will be imposed as well. I believe I said that was followed by 3 years of mandatory parole. If I didn't, that's what I meant. So that's where we're at. Please take care of yourself, okay? Good luck.
Yikes. Yikes. Judge, don't mess around. I don't know how much of that she'll actually do. 6 years or more, anyway. Okay. Listen, I said it before, and I'm going to say it again. This is the most adorable judge anywhere. He just is. He's adorable. I feel like the type of cases that he has to deal with every day he does it every day. He goes in every day and this is
All right, who is Dan Homan? You're Dan Homan. Perfect, wonderful. All right, so Mr. Ferguson, what's going on with this case?
And the feed that he was streaming is choppy, not your YouTube, nothing. You can't fix it. It was his feed that was choppy, but we can hear it fine.
Your Honor, this is case number 2025-OR-0046 in reference to citation numbers 3027 for a goat running at large that was issued on December 18th. Prior to this citation, there is a history at this property in the past of their dogs running at large. So the guilty party is fully aware of the Dawson County Animal Ordinance and that their animals should not be roaming off property without proper containment procedures. After the owners received the appropriate number of warnings, they were cited after both Animal Control Officer Megan Kessinger and I both witnessed the goat running at large for the final time.
All right. All right, Mr. Homan. So you heard my big long spiel. Hopefully you heard most of it. If you have any questions, I will entertain those now before I get started. Do you have any questions for me?
Yes, sir.
Yes.
I've since got rid of the goat.
Okay.
Because I couldn't. It turns out someone down in the same neighborhood has goats that went into heat. And that's why we found out why the goat kept getting out. As much as we tried to contain it, we couldn't. So
goats are finicky. I get it.
So once we got the ticket, well, okay, we're done with it. And we got rid of the goat.
We're done. Okay, perfect. So compliance going forward is not going to be an issue.
Right.
Wonderful. Perfect.
And about the dogs, we did have a problem with the dogs before, but I think he can stay. We've fixed that problem too.
We did fix the problem. Perfect. Wonderful. Great. All right. So obviously then, since you've gotten rid of the goat, I'm assuming you don't want to go to trial. You're just ready to just kind of close everything out as much as possible, right? Perfect, great. Did you want to do guilty or nolo contendere?
Guilty.
Guilty, perfect. And then my fine is $250. Are you able to pay that?
Yes.
Okay, perfect. Can you pay it today?
Yes.
Perfect. And that gets it completely done and out of everybody's hair, and we don't have to worry about it again. Same documents for you to sign, sir.
This is Dawson, Georgia.
First one just says that you have the right to an attorney, you know what nolo contendere is, all that kind of stuff. Just initial those first 3 lines for me, and then sign at the bottom where your name is. And then the other document is just, again, it's your plea sheet showing that you're pleading guilty, you're giving up the rights, you'll initial that 1 line on the first page and then sign on the second page for me. Thank you. All right, court will accept the plea of guilty regarding 2025 OR 0046, goat running at large for Mr. Dan Homan, assessing a fine of $250, including of all costs. Once you get copies of all that paperwork, you're good to go for the day. To be able to pay, if you'll just go out the doors over to Magistrate Court's office, they can take all the payment over there, okay? Just hand them the paper.
Imagine him not getting a job in the future. or starts dating and the lady finds out he has this on his record. It's like, no, forget it. You have a record. I'm not interested.
The work that I gave you, and you'll be good to go, okay? Perfect. Anything else?
No. No, I was hoping for some leniency.
I know, I get it. I understand.
I hate paying $250 fine for a $100 goat.
Listen, I get it. I understand.
I could not be married to this judge because he answers all conflicts with the same thing. I get it. I understand. Sometimes it's very serious. Look, I understand. I get it. I understand. And then sometimes it's funny. I get it. I understand. But could you imagine every time you get into a fight with your husband or wife, they're like, I get it. I understand. I get it. I understand. I'm not agreeing with you, but I understand.
I understand completely. Unfortunately, I can't. I got to be consistent as much as possible. But once you get that paperwork, you're good to go, okay? And this will be behind you. No more goats.
No more goats.
No more goats.
That's sound advice for all of us, guys. No more goats.
This one. That's the goat. That's the goat file. All right, Miss Bearden, if y'all coming up for me, please, dear.
And then I actually had to cut a case out because it was way too sad. This poor judge.
All right, Mr. Ferguson, what's going on with this one?
Your Honor, this is case number 2025-OR-007 in reference to citation number 3.
He should announce all murder cases all over the world from now on. He should announce them.
028 for 2 dogs running at large, resulting in an attack on a neighbor's donkey that was issued on December 22nd. She was here last month to answer for her first citation in regards to this issue where her dogs had attacked a neighbor's cat several weeks prior. The citation we are currently addressing is a subsequent incident involving her dogs attacking this said neighbor's donkey. Since this second recorded incident of
Donkeys are tough. Donkeys will literally kick you and crush you.
Miss Bearden's dogs running at large, she has relocated the dogs to a new home with relatives that live outside of the county. Due to the remorse that she has displayed over the course of the investigation and her promptness in finding the dogs a more suitable home so that this does not occur again, I would ask that our charge only be that of a first offense rather than a second, Your Honor, and that you work with her in regard to her financial situation. I will say I also have the complainant's vet bill information for the costs of treatment of his donkey, and I would like to present them to you today with the intent of organizing restitutions for the injured party.
Okay. Thank you.
I will say at the bottom, in case you don't see it, he's already made a record. When you see at the bottom, it's just
Sounds like ex parte communication going on at the bench. Objection, Your Honor.
Understand. All right. All right, Ms. Bearden,
Yes, sir.
you've heard my spiel twice.
Yes,
What do you want to do, my dear?
I'm guilty.
You're guilty. Well, you're not guilty.
Well, the dogs.
The dogs, okay. I got it.
Those dogs. I'll never have no more bulldogs. I'll stick with my chihuahua.
Listen, be careful with chihuahuas now.
That's what I get told every day.
Careful with chihuahuas.
She's just an old little girl, though.
Oh, okay. Well, as long as she's that, she's fine.
She just wants her eating pad.
Oh. I'll tell you, most of the time that's what I want. It's my own heating pad.
That's what happens when we start getting old.
You're telling me. All right, my dear. Let's see here.
Isn't he adorable?
Let's talk about, we've got a $250 fine. And then we've got the $764.32. Ooh, that is not right. Don't want 76,000. 764.32. There we go. Plus 250. That comes out to a total amount, fine and restitution, of $1,014.32. Okay. Obviously, I'm not expecting you to pay all of that today. And I think that, you know, predominantly for me, you know, if we can get, you know, like $150 for the county's time that was involved with it, and then we can get full restitution for the individual, I'm pretty okay with that.
Okay.
So that we can drop that down 100, takes it down to $914.32. We can still work through like some sort of like payment plan that can work with you, okay? What works best? How much can you pay? How often can you pay? What do you think?
It would be the 5th of each month.
5th of each month.
And it's 9/14.
Yes, ma'am.
I pay $150 today.
Okay.
Could I pay like $250 each month until it's paid?
That's perfectly fine.
Okay.
If you can do that, that's perfectly fine.
Okay.
So $150 today.
I appreciate you working with me.
Oh, yes, ma'am. And then you said $250, right?
Yes, sir.
Okay. And on the 5th?
Yes, sir.
Every month on the 5th.
It'd be like in 3 months.
Yeah, it should be. Let's see. We do 150 today. That gets us down to 764. 250 in March, 250 in April, and then the last one you have is 264.
Okay.
That you could pay in May, or you could break it up and do a May and a June, whichever one you wanted to do.
All right, thank
Okay.
you.
Whenever you come in to pay, you'll get a receipt that shows how much is still left on the balance, and you'll be good to kind of figure out how you want to structure it, okay?
Okay, thank you.
If for any reason you're able to pay earlier and want to, you can do that. No issues with that at all, okay?
Okay, thank you.
Yes, ma'am. All right, let's see here. We've got 150 in that. And restitution of 764.32. All right. There's the disposition order. All right, my dear. So make sure I sign that. Yep. Same two documents. First one just says that you have the right to an attorney. You could qualify for one. You understand nolo contendere, all that stuff. You will initial those 3 lines that I've marked for you, and then sign at the bottom where your name is. And then the second document, again, just goes over your rights. The little initial line is for giving up your right to an attorney and proceeding with your plea of guilty. And then on the last page is a signature line for you right at the top. Did not. All right, perfect. Okay. All right, with regard to 2025 OR 0047, one count dog running at large resulting in bite for Ms. Wanda Bearden, the court will accept the plea of guilty, assess a fine of $150, restitution for the victim, and the total amount of $764.32 for a total amount of $914.32. Gone over the payment plan, $150 today, and then $250 every month on the 5th thereafter until paid in full. I'm not going to set any sort of hearing for compliance or anything like that because I'm going to assume you're going to pay. If for some reason you miss a payment, I'm going to send out a notice. Okay, that's the bad one. That's the one where we have to have a heart talk. So just, you know.
And if I miss that, I'm really in trouble.
And then if you miss that, unfortunately, yes, you're really in trouble. So don't miss that one. Okay.
No.
Don't miss that one because I don't like putting people in public accommodations. It's not fun.
No.
But once you get everything paid, you'll get a final order that says everything's done, closed, final, we're done with everything. Okay.
All right. Thank you.
Once you get copies of everything, you are good to go.
Okay. Thank you so much.
Yes.
Okay. It's not over yet. The stream's not over yet. I'm going to play more court. But that's the amount of court that I had ready. So last night after the live stream, I started to get more content for this live stream. But man, I was hit back to back with these sad cases that I had to walk away from. And one of them was in this courtroom. Another was Judge Caulfield or Crawford, or a mixture of that. You know, in Georgia, the cranky judge, he finally streamed again. I was so excited to get his content. I was actually even just going to put it on press play. And then we watch his docket, because we haven't seen him in so long, and we miss him so much. Oh my gosh. He has such a horrible case in front of him right now, and it's been 2 days. I don't know if it's over because I didn't. Once I heard what I can't unhear and heard how horrible it was, I walked away. I'm like that's it. That's enough. I need to get out of here. And I went and I grabbed a romance novel and closed my eyes for a few minutes because I couldn't. So I didn't get any more than 1 hour and 18 minutes of content ready, but. Judge Eric Johnson, his court, I think a couple days ago, his court streamed. So I got it. However, I'm going to fast forward it a little bit, but listen. Are you ready to listen? Not playing. Come on. See if I can get it to play. Let me try something else. It just decides not to play sometimes when I say play. But I'm going to win. All right. I don't know why it's not playing. Never mind. It's some other judge. It's some lady. And I don't know why it's not playing, but don't worry, I got something else. We'll just skip that one for now. I have 11 hours. No, it's not. It's 4 hours of Maricopa. So we're going to watch Maricopa for a minute. If it plays.
Wish to be extradited to Nevada.
Okay, so you are going to be waiving some rights, so I'm going to ask you some questions to make sure you understand. Did you get an opportunity to review the laminated card that was given to you?
This is ridiculous.
Sí, sí la leí, solamente que no entendí muy bien lo que se refería.
Well, this
Yes, I
might be
did
the end
read
of the
it,
stream.
although
'cause
I
can't
did
get
not
technology
understand
to work.
fully what it meant.
Can anybody hear the courtroom? Not me.
It discussed
Can you hear
the
the
two options we
courtroom?
just talked about. Understand that you do not have to sign this paperwork?
Sí.
It's my software is saying the sound is playing. I cannot hear the sound. So I'm just going to press play and let it play for a few minutes and then end the stream. I won't be able to hear what they're saying though. I have no idea.
Yes.
And do you understand you have the right to an extradition hearing?
Sí.
Yes.
18 months. Wow, Martha, thank you so much. Thank you.
Do you understand that you have a right to hire a lawyer at your own expense?
Sí.
Yes.
Do you understand that you have the right to demand that a governor's warrant be signed by both governors before you are returned?
Sí, sí entiendo.
Yes, I understand.
Do you understand you have the right to bail? That is the $20,000 cash we discussed.
Sí.
Yes.
Do you want to give up those rights and sign this paperwork?
Sí, está bien.
Yes, that's fine.
Has anyone threatened you or promised you anything to get you to sign this paperwork?
No.
No.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No.
No.
I find that you are knowingly, intelligently, and voluntarily signing the waiver. I am also going to sign it. I am directing the sheriff's office to notify the requesting state that you are ready to return. They will have 30 days from tomorrow to pick you up, unless you have charges pending here in Arizona. If you have charges pending, the 30 days will start at the conclusion of that case. Did you have any questions?
¿Tengo el derecho a que alguien me visite aquí en estos 30 días?
Perdón, señor, repita. The interpreter said repetition, Your Honor.
¿O tengo derecho a que alguien me visite en estos 30 días que estaré aquí?
During the 30 days that I will remain here, do I have the right to have a visitation?
That will be determined by Maricopa County Sheriff's Office, but typically the answer would be yes.
Okay.
Okay.
Anything further before we sign the paperwork?
No, solamente quiero saber si la decisión que estoy tomando es la correcta y si es recomendable.
I just want to know if the decision that I've made is the correct one, and is that something that can be recommended?
You would have to discuss that with an attorney. If you are not comfortable making this decision today, I can set that hearing on February 23rd. That would give you an opportunity to contact an attorney, and they'll give you this option again on that date. If you choose to sign the paperwork today, then you won't be before a judge in Arizona. Again, you'll be waiting for Nevada to pick you up.
Es que nunca he contratado a un abogado y no sé si salga muy caro, no sé si vaya a poder poder pagarlo, por eso no sabría. Pero creo que la mejor opción sería que me extraditaran y seguir con mi caso allá en Nevada.
Well, I've never hired an attorney before. I don't know if that will be too expensive, and so I don't know if I will be able to afford one. But I think that the best option here would be to be extradited to Nevada and proceed forward in my case there.
Okay, if you will step over to where the officer is standing right here, she will direct you when it's time to sign the paperwork.
Yeah, thank you.
Thank you.
Please keep the headphones on. And Mr. Venegas, he did remove the headphones. He is signing the paperwork right now. It'll probably be just a few more moments.
Thank you, Your Honor.
You're good?
Mr. Venegas, while we wait, would you make a general call to the gallery to see if there's anybody else that will need your services?
Yes, Your Honor. ¿Alguien más aquí ocupará interpretación? En español, alguien aquí no habla inglés y ocupa intérprete. Levante la mano o diga su nombre.
All right, nobody has indicated, and let me just double check on Mr. Romo.
I'll go fast forward it because I got 4 hours and there's no reason why we should stop at the part where nothing's happening.
For $1,500 total. If you bond out, comply with all of your written conditions, do not miss your court dates. If you accept your left, you've got a copy of your paperwork. Thank you. All right, Ms. White?
Do you have a bond?
Yes, it's $1,500 total for 3 cases. All right, Ms. White? And then I need Anthony Castillo, please, to the chair. Right here, ma'am. Yeah.
Ms. White?
All right, good morning, ma'am. Can I have your full name and your date of birth?
Santana Patricia White, sorry, July 5th, 1985.
All right, thank you. You're here on 2 things. One's a warrant from the West Mesa Justice Court, and one's a new arrest.
Can I speak?
Not yet, ma'am.
Okay, I'm sorry.
I have a fundamental duty to tell you what's happening.
Sorry.
So I do that, and then I give you a chance to talk.
I'm sorry.
That's all right. So I'm going to start with your new arrest. You were arrested on allegations of possessing dangerous drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you. Your court dates will be a status conference February 10th at 8:30 in the morning, which is this Tuesday in the downtown Superior Court. Your preliminary hearing will be Thursday, February 12th at 8:30 in the same court downtown. In the Justice Court, this is out of the the West Mesa Justice Court.
Yes.
This is your old issuing a bad check case from 2007. They've issued, not yet, ma'am. They've issued a warrant for failing to appear post-conviction. And this went out October 22nd of 2025. I'm going to tell you what's in the court record. I will give you a chance to talk. And so what this says is that back on, hold on a second, because as you know, there's a lot of records in your case. Give me a second. Alrighty, on September 25th of last year, you stood in this courtroom before a judge, and that judge released you on your own recognizance to go to court on October 14th. You weren't there, and then the warrant issued. That's what I see in the court record. So All right, now I'm looking at a court date of February 9th at 8:30 in the West Mesa Justice Court. Now, what did you want to tell me?
Sorry about that.
It's okay.
So I sent in a payment already.
Mm-hmm.
I sent in a payment for the checks, okay?
Okay.
I need to pay one more payment and I'll be done with it. I have my proof at home. I got all everything.
I don't see any payment on here. This doesn't file payment records. I show the last payment in November of 2024.
No, I promise you I did. When I got out of jail that day, okay, I went home. My mom helped me pay it. We sent it in.
Oh, but then you didn't go to the court hearing.
I didn't know I had to. To tell you the truth, I didn't know I had to go to court. I thought I just had to make a payment for my check.
Well, and so here's the problem: is you have a long
on the same
history
thing.
of doing the same thing.
No,
we
it's
release
not.
you, we OR you. I'm looking at it, and this goes back a decade. We OR you, and you don't physically go. So, ma'am, I don't believe that you thought you didn't have to go. I literally don't believe it. It is just this record is absolutely replete with trips through court. You promised to go. There's no judge down here who would have said anything other than you have a court date. So this court is going to give you a $50 bond in each case.
Wait.
It's $100. What's your question?
Now, can I say something?
Mm-hmm.
Please. I have to get to work. If I miss one more day, they're gonna fire me.
Your credibility is very, very low, ma'am. And also, unfortunately, you came in. I do not believe you have a job either, ma'am. Because
I do.
Because I don't believe it. What I'm
ma'am.
saying is, there's no way I'm taking your word for it. And given the circumstances of your arrest, I believe you're likely on the street. Doesn't preclude you having a job, but also given that it appears you have some other substance abuse issues, you have a massive amount of failures to appear in this case. This court does not have any confidence in you, ma'am. I've set the bond as low as I'm willing to go. It is $100 total. Yes, you can.
Can I say one more thing, please? I do have a job, ma'am. I work at Target. Okay, I promise you.
Okay, but your problem though, ma'am, is you've done nothing, absolutely nothing ever to get a court to trust you. And literally, the little story you told me about your mom and the payment, and then I didn't think I had to go, that loses any credibility when I look at how many times you've been through this court and failed to appear. I literally, that is not in any way a credible story. Please step to your left and take your paperwork. Good luck. Now, Mr. Castillo and Jeremy Studham, will you go to the chair?
Good morning, Your Honor.
Hello, sir. Can I have your full name and your date of birth, please?
My full name is Anthony Jose Castillo, date of birth 5/28/90.
All right, thank you. Mr. Castillo, you're here on one allegation of third-degree burglary. That is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. Your court dates are going to be a status conference February 10th at 8:30 in the morning. I know, just wait for it, okay? Did you not hear me make her wait? Okay. And a preliminary hearing February 12th at 8:30 in the downtown Superior Court. Now, I have a question for the officers before I talk to you. Officer, do you know what city has his hold? Pretrial says he's got a hold at the jail for $500.
Chandler, Your Honor.
Chandler, okay. Mr. Castillo, now I have a question for you. Do you think you're going to be able to post Chandler's bond? There's not a thing I can do about Chandler's bond. That's a yes or no question.
No, I can't post it. I might, it's possible, but that warrant came out from when I got violated, sent back to federal prison.
Okay, I'm not interested in why you have a warrant. You just do.
No, what I'm trying to say
I'm not holding it against you that you have a warrant. All I want to know is, do you think you're going to be able to pay Chandler's bond?
I'm not sure, ma'am, but I have. What I'm trying to say is, to answer that question, is I have been picked up maybe 2 months ago. Okay. And Chandler didn't complete.
Okay, but let me stress again. It doesn't move the needle for me either direction why you got a warrant. I know you have a bond because despite your criminal history and what appears to be a strong weight of evidence on video, I was considering releasing you to pretrial services. Although, sir, you have a really impressively long criminal history. Go ahead.
I haven't been in trouble in about 10 years.
I
got prior from 2018.
I know. This is a non-violent offense. They appear to have the whole thing on video, though. Talk to your lawyer. I'm appointing a lawyer for you, okay? I'm going to set what's called a placeholder bond. It's $50. It's secured. Don't post it because it's meant to give you credit for time in custody because you're stuck on Chandler's. So if you post the whole thing in both cases, that makes it $550, you get out of custody, and in this case, you'll go to pretrial services. If you do bond out, do not go to the scene of the alleged crime. That is this store, the Circle K, do not go there. No contact with any of the employees there, no weapons, no drugs without a valid prescription. Step to your left, get your paperwork.
Hey, Your Honor, you can't release me on your mom regardless?
I won't, sir. I just finished saying that you okay. You have an incredibly long criminal history, Mr. Castillo, and the court does not believe you'll voluntarily appear. Mr. Studem, then Kayla Padron, will you go to the chair? Hi, ma'am. Can I have your full name? Is it sir? I apologize. Can I have your full name and date of birth?
Jeremy Studham, 11274.
Thank you. You're on a new case. You got arrested for theft, a class 1 misdemeanor. There is probable cause for that. I'm not appointing a lawyer for you because I'm not giving you a bond today. I'm going to give you an arraignment hearing February 24th at 9 in the morning in the Peoria City Court. Now, I am very unhappy to read that you're on supervised probation for felonies. There appears to be a very strong weight of evidence against you as well. This is a misdemeanor. So you must go to court, comply with your release conditions. You stay away from this store, which is a Circle K. Absolutely stay away from the store, stay away from the alleged victim. Call your PO within 72 hours. And Mr. Stidham, if you're smart, you'll call your PO today. There's no judge who's going to be happy to see that. That being said, they don't automatically file a petition to revoke on this kind of misdemeanor. They do for DUIs and domestic violence, not for theft. But they absolutely can. And with that weight of evidence in your criminal history, they allege the entirety of it is on video. So you need to call your PO and you need to comply with your probation and all of my release orders. Do you understand?
Yes.
You are released. If you'll step to your left to get your paperwork.
I'm released?
Yes.
Thank you.
Ms. Padron? And then Ariel Woodward, will you go to the chair? Hello, ma'am. You hold on to that. Can I have your full name and your date of birth, please?
Kayla Padron, 12/24/2004.
Thank you. You're on a new case. You were arrested for domestic violence assault and domestic violence disorderly conduct. Those are both class 1 misdemeanors, and there is probable cause for them. I'm not appointing a lawyer for you because I'm not currently planning to give you a bond, and the city courts prefer to handle that question on their own when we don't set bond. So your arraignment hearing is in the Buckeye City Court, February 24th. That's almost 3 weeks from now at 2 in the afternoon. The address is on your paperwork. You always have the right to hire a lawyer at your own expense. If you do, bring them with you.
Okay.
Otherwise, you would be representing yourself unless the Buckeye judge decided to appoint a lawyer for you. I am going to release you. I'm going to give you written release conditions, though. They are all of the domestic violence release conditions. You can't go to or live there. I'm going to finish first. You can't go to or live there while the case is pending. You can do a civil standby with law enforcement to collect belongings. That is the only way you're allowed to go. Otherwise, you're violating this order, which could itself be a felony. No, I guess because this is, okay, no, because this is a misdemeanor. It wouldn't be. No, I'm sorry, I'm confusing myself. You would be bondable, but it would be aggravated harassment. If you do anything to violate my no victim contact order in a way that's harassing, you could be booked for felony harassment. That could be one text. Absolutely no contact with the alleged victim. Don't respond to any.
Who's the alleged victim?
See, and that's important in your case. And I gave this a fair amount of thought because the alleged victim is your boyfriend's mother.
Okay, so I can talk to him, just not her. I can have a conversation.
Right. He is arguably the victim of the disorderly conduct. The police have been non-specific about that, so I'm not ordering it. But I will tell you, Ms. Padron, I gave very sincere thought to calling DCS and reporting this case.
Of course.
Very sincere thought. The baby is not alleged as a victim, but I will tell you, ma'am, that this court, meaning me, we order statewide the removal orders that DCS seeks. So I read domestic violence allegations a lot against parents on behalf of DCS, and if I find there's probable cause for them, I issue an order to remove the child. Your child is 1 year old.
Yeah.
On these facts, which right now are not as well established as I would like, but if the Department of Child Safety came with that and sufficient probable cause, I would have ordered your child removed.
Okay.
That this type of domestic violence, near or slash alleged to involve a baby, if somebody is alleged, and it is only alleged by somebody who may have a motive to make things up against you, said she was having a disagreement to you because you're hitting the 1-year-old. And let me tell you, ma'am, a single strike on a baby, on a 1-year-old, there are experts who will testify in court babies are incapable of conforming their behavior in response to physical violence. They literally can't. And people who beat infants clearly do not understand child development in the smallest way, because they think that striking a baby will result in the baby not crying. But babies can't do the math of let me give you something to cry about.
Do you have a question about that?
Okay, but physical discipline against a 1-year-old is almost per se child abuse. What is your question?
Does she have video proof of me beating the child?
Right. No, they're not alleging that. So I'm making very clear to you, ma'am, because, listen, and I don't want you to say anything that could incriminate you, okay?
Yeah, no.
I'm already releasing you. You're before me for the assault and the disorderly at your boyfriend's mom's house. I just want to caution you. I really want to caution you, because I gave hard thought to reporting your case to DCS. I'm not a mandatory reporter, but I have done it. This is a case where there's a lot of red flags. There's not right now sufficient evidence. DCS would have to investigate, do some type of corroboration, which does not have to be video. Please believe me, it does not have to be video. A single mark on a child doesn't even necessarily take a mark. If you shake a baby, that baby will get brain damage.
Yeah.
And I hope you know that.
Yes, I know that.
And without a single mark on their body, you'll give them lifetime brain damage if they survive it. So I take that allegation, that one gives me a lot of pause, but I'm respecting, my ethical requirements, which is to consider exactly what you've been accused of. They're not accusing you of that. I'm not sure that they reported it to DCS. It looks like maybe they didn't. So I feel an obligation to give you cautions. I'm not finding that you did it. I'm not saying that you did it. I'm trying to impress upon you that of everything I read in there, the thing that gives me enormous pause is the allegation that anyone is hitting a 1-year-old. And so, 1-year-olds are not all created differently. They are all the same. And a 1-year-old could be close to 2, or they could be 13 months old. And so I just want to caution you that is the thing. Any type of allegation like that, that's going to, at best, get your child removed, at worst, get you charged with child abuse.
Of course.
So be extremely careful about that, and you're not currently accused of it.
Okay.
So that's why I'm releasing you.
Yeah.
Believe me,
I do
if you were
have another
booked on probable cause for striking a 1-year-old, you'd be getting a bond.
Yeah, of course.
It'd be a felony.
Yeah.
Okay, I'm glad you understand that.
Yeah.
So,
I don't ever mean to hurt her, like.
well, so like I said, please, this is for I'm trying to help you preserve your rights. It's not that I don't want to hear what you have to say. It's just, I just gave you a lecture that any person would feel like they should respond to. But you have the right to remain silent, and your response could potentially incriminate you. And I don't want you to do that, because I felt the need to give you a lecture because I worry about that child's safety.
Yes, of course.
I don't, because you're already getting the very best result from me.
Yes.
I am releasing you. I just want you to take these release conditions seriously. You can't text the grandma. I assume she's the grandma of your child.
Yes.
You can't text the grandma and say, thanks a lot, or whatever. That would violate my order. You're going to land right back in jail. So you just keep the peace. If your child is there,
No, as soon as I get my phone back, I'm blocking her. I'm not talking to her,
okay,
so.
so just do your utmost to respect the release conditions. They're in writing. Comply with those. Keep the peace.
Okay.
Go to court on the 24th. What did I say? Whatever it's supposed to be on your paperwork. Just go to court,
Okay.
2 p.m. Like I said, if you hire a lawyer, bring them. If you want to ask the Buckeye judge to give you one, they apply their own set of reasons why they do and don't, so it's up to them.
Okay.
I'm just not doing it today.
Yeah, I have my grandparents help me with that, because they've
Okay.
got really good lawyers, so.
Okay.
But I do have a question. Am I able to get my baby and have her with me?
And so, this order does not apply to your child. And actually, let me reprint it, because I want to make clear, I don't want there to be confusion, because it's a disorderly. Give me a second. And so, 1 second, because I have some language that I use that I should have thought to put in here, but I didn't. I'm sorry. Hold on. Okay. Computers are frustrating. I need to pull the language up, and it's going to make it real clear that the order does not apply to your child. You cannot violate the order if on the reason of I had to see my child. You have to go to family court and deal with that. If for some reason you're not able to figure out a way to see your child, if you've got family who can help, go-betweens.
It seems like they're keeping her from me.
Well, and again, this is not a family court order, but there is no defense. It is not a defense to violating these release conditions in a criminal case to say I had to exercise my parenting rights. And that's why I like to have it in an order, because then you can never say you were confused on that point. So hold on a second. I just got to find it, and then I'll also read it to you.
Okay. So if I can't go over there, how do I pick her up?
Yeah, that's what you're going to have to figure out. And I'm not a family court. We are not a family court. And so my orders are pretty black and white on purpose. And I always tell people in your position, I know it can be extremely hard to be away from your child for a bit while some of this plays out. But the very worst thing you could do is decide that it's better to violate this court order, because that's the thing that may land you in jail. And what that means is you may not see your child for a window while this gets sorted out in the court system. If that's true, it is far better than the alternative of being locked up, potentially being charged with felonies, and having all of that used against you in a family court case. Already, this arrest is going to end up used against you in a family court case. So talk to your lawyer about that. So I don't make a bad situation terrible by violating my order because you missed your child. And so family court is separate. So this will say this order does not apply to you only have one, right? You don't have multiples? Okay. This order does not apply to your child. However, you're not permitted to violate it in order to exercise any parenting rights you may have. If you are unable to exercise your parenting rights without violating this order, then you must seek an amended order from the court in this criminal case, which means Buckeye, the Buckeye City judge. You file a motion, you do things there. You said your grandparents can help you with a lawyer. That's a good thing. You may not violate the order while you're waiting for a ruling on a motion to modify it. But right now, this court is not in the business of carving out the preservation of people's parenting rights with, handoff rules and all of that. That is for family court or civil court, okay? So we don't do it. I've got a crime. I've got somebody with probable cause for it. You're the one who gets the orders put on them. We don't do that. We don't put orders on the victims. And also, we literally don't have power to do it. I don't have any power over him or his family. A family court might or should. A civil court might or should. I categorically don't. I only have power over you and the prosecutor.
Okay.
So everything's on your paperwork. Go over it with a lawyer. Read it for yourself. It takes hours to get out. Try to be patient. You'll be out later today.
And I do have another question as well. Just one last question. So we have a joint bank account, me and him.
Yeah.
That's...
Talk to a lawyer.
I
can't give you legal advice.
Okay.
I can't. Sorry. That's a thorny issue potential.
She is not going to stop until she says something wrong. I just wish she would shut up right now.
So I definitely recommend you talk to a lawyer.
Okay.
This up to us to get the paper.
All right, thank you.
She got lucky. Oh, she got so lucky. She got so lucky the paperwork wasn't right, that they didn't ask enough questions when they arrested her. If they would have asked just a few more questions when they arrested her, DCS would be all up in her business for a couple years. Whew. She's so young. She's 21. She was born in, she's going to be 22 this year. She could already be 22, but maybe. It's only been a couple days. It's already February, though, guys. Christmas is coming. All right. Thank you so much for coming out today. I really appreciate it. I really, really, really do. I hope that you guys have a great day. What is today? I don't know, but I'll see you tomorrow. Today's Thursday. I'll see you tomorrow, guys. Have a great day. Bye.
Well, I thought I'd write a happy song. I found a chat room where much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time.